Okay. We concluded with the Friends of the Earth and Sierra Club Office of Regulatory Staff.
Thank you very much, Mr. Chairman, Commission. Office of Regulatory Staff's first witness, Kenneth Brown, former senior engineer with SCENG on this project, is out of state today and unavailable. The parties, I'm fairly certain, will be filing a stipulation to have his deposition admitted and exhibits admitted into evidence. And we will ask to play short excerpts of his videotape deposition at the end of the ORS pre-filed testimony next week as part of that stipulation. Okay,
we'll hold it all in abeyance on Mr. Brown till we.
No problem. Thank you very much, Mr. Chairman. ORS's second witness is Ms. Carlette Walker, again, former corporate officer of SCENG, and she has already had her stipulation as to her depositions, both transcripts unredacted and all exhibits. That stipulation is moved into evidence, and we have either already filed some, if not all of that deposition transcript and exhibits, and they will be filed very shortly. And we would move on the basis of that stipulation her unredacted deposition testimony and all exhibits to her depositions into evidence at this point.
Yeah, go. Please.
Yes, Mr. Richardson, one technical question. Do you want her testimony read in as if given orally from the stand and her exhibits made an exhibit, or do you just want the whole package to be made an exhibit?
I think we'd like the whole package to be made an exhibit to the record.
All right, sir. And
similar to the previous statement, that we would like to play short excerpts of her video deposition at the end of ORS's pre-filed testimony.
Yes, sir.
Walter.
Thank you, Mr. Chairman. The stipulation that was filed this morning with respect to Carlette Walker and that we agreed upon did not contain any agreement or discussion about playing any snippets of video. This is the first I've heard of that. We did not agree to that. That is not in the stipulation. And if the other side is going to designate portions of her testimony to be played, then there would need to be counter designations of her testimony to be played as well. So I certainly agree, and we have agreed that Ms. Walker's deposition transcript should be submitted into the record fully, unredacted, with exhibits. We're in agreement on that. We have not discussed or agreed to any playing of a video, any snippets of video, and the same is true with respect to Mr. Brown. We have agreed that Mr. Brown's testimony could be submitted by deposition with his exhibits fully, but there's been no discussion at all or agreement about playing any video, and we would certainly need to have the right to cross-designate portions of his testimony to be played as cross, if that's the route that is now being suggested by ORS.
Hey, Mr. Richardson, would you be willing to just follow your original stipulation with regard to Ms. Walker at this time and put the deposition and exhibits in, and then you can discuss the remainder of it with counsel and perhaps come back to the commission at a later date about that?
Yes, thank you very much.
Okay. Mr. Chairman, the motion is, I believe, to put in as the next hearing exhibit the unredacted deposition of Ms. Walker and the exhibits, okay, which would be number 12.
Okay. Ms. Walker's exhibits will be, this is her deposition, will be unredacted deposition is hearing and exhibits is hearing exhibit number 12. So is Ms. Walker not going to appear?
She is unavailable, unfortunately.
Okay. Is there a good reason for that? I know the commission was very interested in hearing from her.
There is. She's sat for numerous hours of deposition testimony, and I don't think it's on the record, but she has expressed great concern and emotional strain from not just the process, but from executives and individuals that here that he frankly we were told would have a letter from the doctor explaining. We do not have that, unfortunately, but Mission desires more information. We can certainly get that from her attorney
Okay.
But we've stipulated that she's unavailable, and I don't know whether we can do anything about that.
Okay.
I'm told it is on the record in the deposition transcript.
Okay. And Mr. Brown is not going to be here, or is he going to be here later? You said he was.
He is out of state, and he's not available today. And as a result of that, we've asked for the stipulation because of the uncertainty of whether we can, whether he will be available to come. And in part, following some of the directives of the commission hearing officer, not to deprive you of them, but to submit in written form as much as possible, and to hold us to what we said the order of our witnesses were, which we already are, moving faster, and that's a positive thing. I think we'd recognize there's a corresponding detriment that you all are not allowed, permitted to ask them if they're not here, and we think that's more than regrettable.
Man, I've got some over here.
Interrupt my own counsel. But I think our intent was actually to have the deposition testimony read into the record as if given orally from the stand as testimony. And the exhibits to those depositions placed into the record as the next composite hearing exhibit.
Okay, well, Mr. Richardson, do you defer to Mr. Nelson on this?
Absolutely. I stand fully corrected, and apologize for not looking in the right direction when seeking guidance on that. Our intention was to have them here testifying in person and from the stand, and to adopt as their testimony those deposition transcripts. So please allow me to adopt Mr. Nelson's position.
Okay, so Mr. Chairman, as I understand it, they're now asking that the testimony of Ms. Walker be read into the record as if given orally, and that her exhibits be marked as the next hearing exhibit. In a correction.
Okay, we'll do that. We'll have her testimony read into the record as given orally from the stand, and her exhibits will still be hearing exhibit number 12. Okay, Commissioner Howard, do you have a question?
Yeah, I guess I can understand sick, but being out of state, when the date of this hearing has been known for months, why is he out of state? Why isn't he available?
Mr. Commissioner, when we were talking with him after his deposition, we understood that he was subject to being deployed. It may not be the right word, but deployed to work with FEMA in other parts of the country. I do not know if that's why he's out of state today. Part of it is that we didn't anticipate, we didn't really know that he would be called as a witness today. But his counsel has not accepted the trial subpoena, and he's not available, and we're constrained by that. And I can tell you that regardless of the stipulation, if we can get him here in person, I can assure you we would like to, and we will. Thank you.
Okay, yeah, we're keeping Mr. Brown in abeyance until we figure out what. Okay, move on.
Thank you, Mr. Chairman. Office of Regulatory Staff calls Ms. Elizabeth Warner, the Corporate Secretary of Santee Cooper. Please tell the commission your name and position at Santee Cooper.
Yes, my name is Elizabeth Warner. I'm the Vice President for Legal Affairs and the Corporate Secretary for the South Carolina Public Service Authority.
Yeah, we need to get that. You're a little closer to that microphone.
All right.
Let's do that again. Just make sure we get you on.
Yes, sir. My name is Elizabeth Warner. I'm the Vice President for Legal Affairs and Corporate Secretary for the South Carolina Public Service Authority.
Ms. Warner, did you prepare pre-filed testimony both dated August 14th, 2018 and on September 24th, 2018, and which was amended on October 30th, 2018 in this matter?
Yes, I did.
And is the content of your pre-filed direct testimony true and correct?
Yes, it is.
And did you also prepare a certification of documents by the Corporate Secretary of South Carolina Public Services Authority, or Santee Cooper, dated October 31, 2018?
Yes, I did.
And is that true and correct?
Yes, it is.
Commissioners, you have that at tab 3 in your notebook provided this morning, the certification. And were the exhibits and charts that are included or attached to your pre-filed testimony and your certification prepared by you or at your direction based on activities of Santee Cooper and pursuant to its public duty of Santee Cooper and its records?
They were prepared by me or at my direction pursuant to my instruction, and they are public records of Santee Cooper.
And these exhibits and the documents that they identify are the records of Santee Cooper about the project and maintained and produced from the files or records of specific public officers and employees of Santee Cooper?
That is correct.
And none of these records are accident reports or law enforcement investigative notes, are they?
They are not.
Oh, we need you to get a microphone.
I'm objecting, Your Honor. The council's gone far beyond the scope of pre-filed testimony in this matter. The pre-filed testimony merely says that the records are stored in the ordinary course of business, and all pages are true and authentic records, authentic reproductions of documents in Santee Cooper's possession. That is facially inadequate to establish that a record is a business record that can be admitted. It is a very complicated showing in order to do that. So we object to expanding the testimony during the summary to try to make up for this defect, and we don't believe the defect can be made.
Mr. Chairman, showing a basis of a business record is not a very taxing or complicated process. It's not intended to be. It's intended to show reliability. And in fact, in the certification, it clearly shows that these are not just business records of a corporation, but they're actually public records of a public agency, which is a separate basis altogether. And I might just point out the paragraphs 6 and 7 on page 3 of the certification, which itself is designed and is normally allowed, even in court settings, much less a more relaxed evidentiary setting as an agency, to permit records custodians to simply present public records that, by the rules of evidence, are themselves reliable and admissible on that basis to be considered and used. And we're about to go over the 10 documents that SC&G continues to object to, and you'll see exactly why all of these records should be admitted into evidence.
Chairman, the admission of these records has to be made on the testimony that was filed. To be admitted as a public record, it has to be shown that the matters were observed pursuant to a duty imposed by law as to matters where there is a duty to report. That's Rule 803, subpart 8. There is no showing that there is a legal duty on Santee Cooper's part to proffer any or to create any of the mixed group of notes, emails, and other documents, many of which are unattributed, and therefore these documents cannot be admitted into evidence as public records. They also fail to qualify under the very complex terms of a business record, which is limited to something that's done in the ordinary course of a business. It doesn't include emails, notes, thoughts, general observations. You have to show a legal or a business process which is being followed, which is not shown here. We don't believe it's appropriate to expand the scope of the testimony to attempt to go beyond what is there. We think, based on the testimony, these 10 records need to be denied entry into the record of this proceeding as exhibit.
These, I think it's would be shocking to the people of South Carolina to hear that Santee Cooper did not have a public duty to both keep and report and record about the VC Summer project. I think that is hard to even argue against, frankly. But what's more important is that the public records exception to hearsay is exactly the reason why you have usually just a records custodian affidavit. We have the records custodian here, the corporate secretary. We have 10 documents that the SC&G continues to fight about. We're about to show through this witness why they should be admitted. We should at least get through the testimony in order to either satisfy or not the commission on these documents.
Okay, I'm going to let you proceed, noting your objection, and we're going to rule on that in the final order. So,
thank you very much, Mr. Chairman.
Yes, sir.
Chairman, will I have any ability to examine the witness as to the matters that are now being elicited for the first time without pre-filed testimony into the record in this case?
Yes.
And we fully expected that they would have cross-examination of this witness. Ms. Warner, are you aware that there are now objections to only 10 Santee Cooper documents?
Yes, I was informed of that today.
Thank you. Let's look at those 10, each of those 10 documents. Approach the witness, Mr.
Mr. Richard.
This document is identified as the Bechtel Report Action Plan, and at the bottom contains the Bates number ORS_00008486. Ms. Warner, can you tell us about this document?
Yes, this is a document that was kept in Santee Cooper's files and records, in particular in Mr. Lonnie Carter's file. He was our CEO at the time. It's a document that was drafted by Mike Baxley with regard to the nuclear project.
And can you tell us just a little bit about the mode and practices of Mr. Lonnie Carter's record keeping?
Mr. Carter kept a set of files on the nuclear project, and when we began with the follow-up to the abandonment of the project, we gathered documents from Mr. Carter and others, and this was among the documents that was gathered from Mr. Carter from his nuclear file.
Anything else about this document, Ms. Warner?
No, sir.
I'd like to approach the witness and hand document number 2. Handed Ms. Warner the document identified as the Quarter 2 President's Meeting of June 30th, 2016, with a Bates stamp at the bottom of ORS_00006973. That's the 7/8. Can you tell us about this document?
Yes, this document is also a document that was located in Lonnie Carter's nuclear file.
Based on his what you know of his record-keeping practices, this is part of the public records and of Mr. Carter?
It is a record of Santee Cooper and a public record.
Thank you. The third document that SC&G has objected to is an October 1, 2015 draft letter containing Bates number ORS_00008744 to 78. And Mr. Chairman, we withdraw that exhibit based on the objection by SC&G. Chairman, I've handed Ms. Warner the fourth document for which an objection still exists. This is a February 13th, 2017 communication memo of Santee Cooper, which is the Bates number ORS_00010055. Ms. Warner, can you tell us about this document?
Yes, I can. This is a document that was located in Mr. Carter's files. It is a memo from Mr. Carter to our Board of Directors regarding our board meeting dated February 13th, 2017, and is a document that would have been provided to the board prior to that board meeting.
Mr. Chairman, I've handed the witness the next, I believe it's the fifth document objected, still has an objection. This has a base number of ORS underscore 000-11042. Can you tell us about this document?
Yes, this was a document that was located in Mr. Carter's files. It's a document letter on Santee Cooper letterhead signed by Mr. Carter and addressed to Mr. Hines, Chairman of the Central Electric Power Cooperative, and Mr. Hochstetler, who is the President and CEO of Central Electric Power Cooperative, dated June 26, 2017, which was in Mr. Carter's files.
Ms. Warner, you would recognize Mr. Carter's signature, not,
Yes, I do.
and is that Mr. Carter's actual signature?
It is either his signature or an auto signature that may have been used, but it certainly looks like his signature.
And was it part of his record keeping and practices in the business to have an auto signature to sign his name?
Yes,
He approved that.
yes.
Thank you. Mr. Chairman, I've handed Ms. Warner the next exhibit to which there's objection. I believe it's number 6. At the bottom is the bait stamp ORS underscore 000-11063. Can you tell us about this document?
Yes, this is a document that was located in Mr. Carter's files. It is an email from Mr. Carter to Rob Hochstetler with several others copied, dated May 3rd, 2017. It is a Santee Cooper email, as noted by the warnings on the bottom of the email, that it was received by Santee Cooper and responded to by Mr. Carter.
And you can see there's a BCC line, blind carbon copy line, that
Yes, there is.
there are Santee Cooper emails. Are those, is that the correct domain name and email address for Santee Cooper public employees?
It is, and those are all Santee Cooper employees who are copied on the BCC.
Thank you very much. Mr. Chairman, I've handed Ms. Warner the next document that still has an objection to it. It is Bates numbered 11588, which doesn't show on this particular version, ORS underscore 11588. And Ms. Warner, can you tell us about that?
Yes, these are documents that were supplied to the Santee Cooper Board for the Friday, June 17th, 2016 meeting. They include an agenda, styled amended agenda. They include draft minutes from prior meetings, and they include a memorandum from Michael Crosby, who is our Senior Vice President for Nuclear Energy, to our Executive Corporate Planning Committee regarding the VC Summer Nuclear Unit 1 Operating Report, which is a report that was made to the board over the course of the nuclear project. And it contains some additional board documents, including a report from Howard Axelrod, which was supplied to the board for its review and information.
And as the corporate secretary, are you familiar with this particular set of director meeting, executive committee, planning committee meetings?
Yes, I am. I would have been involved in providing that information to the board and would have directed my staff to do that.
Chairman, I've handed what is the ninth remaining objection to Santee Cooper documents to Ms. Warner. Ms. Warner, can you tell us about that?
Yes, this is a document that was actually forwarded to me by my assistant corporate secretary, and the original document was an email from Mr. Carter to the board transmitting Toshiba market reports, and this would have been done on April 11th, 2017 as a part of information provided to our board.
And this is an email that you actually received during the time of the project and before abandonment, right?
Yes, it is.
And the market reports, there are two of them, one's 23 pages and one's 2 pages attached to this email, were actually embedded in the email if you turn to page 2. Can you see that?
Yes, you're talking about the link, or
Well, and there's a box that didn't print because of the format.
okay. Yeah, it's my belief that the board received this information either through the email or as an attachment to the email.
And also, you actually received it in the course and scope of your duties for Santee.
I did.
This is, Mr. Chairman, I've handed Ms. Warner the ninth. I may have gotten the numbers wrong, but this is the ninth remaining document objected to by SC&G. It is Bates numbered ORS_000400162. Ms. Warner, can you tell us about this?
Yes, this is a note that was located in Jason Williams' file at Santee Cooper. Jason Williams is a member of our nuclear team.
Can you tell us about the mode and practices of Mr. Williams' record keeping?
Mr. Williams kept a file on the nuclear project in the same fashion as other members of the nuclear team, and when the project ended, we gathered those documents, and this is one of those documents that was gathered.
Chairman, I've handed the 10th and final document that remains with an objection by SC&G to Santee Cooper documents. Ms. Warner, can you tell us about this?
Yes, this is a document that was also located in Mr. Carter's file. It's an inter-office communication on Santee Cooper letterhead to Jim Brogdon, who was our general counsel at the time, and Steve Pelcher, who was our deputy general counsel, from Lonnie Carter regarding a consortium meeting regarding summer units 2 and 3 on September 18th, 2013.
Thank you very much. And can I refer you back to your certification now, paragraph 8? You attached a certification exhibit 1, which identified the individual documents that you addressed in your testimonies and in this certification, and provided the individual custodian of each of those documents. Is that right?
That's correct.
And are each of these 10 documents already listed by Bates number and custodian on that Exhibit 1 to your certification?
Yes, they are.
And are you familiar with the Bates numbering that we've been referring to?
I am generally familiar with the Bates numbering.
Are you familiar that these are documents that were provided, found both in Santee Cooper's public records and files, but also provided in response to request in this matter?
Yes, I am.
And all of these documents were both identified as responsive and provided by Santee Cooper in response to those requests?
That's correct.
And to the best of your knowledge, are all of these documents both authentic and reliable?
They are authentic business records of Santee Cooper, which were kept in the normal course of business and which were located and provided pursuant to the request.
And are they also public records kept pursuant to the public duty of Santee Cooper and involved in this project?
Yes.
As a partner of SCNG?
Yes.
Mr. Chairman, I move for the admission of all of these except the one withdrawn exhibit, as well as all of the other Santee Cooper exhibits to which we've been told there is no objection.
Mr. Chairman, SCG reasserts its objection. We can go through document by document here and take up valuable hearing time, or we would propose this. The ORS has made its case as to what it believes is the information necessary to satisfy either the public records or the business records rule as to these documents. We would suggest that we would like to take that information, which will be available in a transcript as soon as which will be done very quickly, and do a written briefing as to each of those documents and provide that to you so it can be decided on a written record rather than through using hearing time for that. And we will keep those objections open until the briefing, if that's acceptable to the commission.
That's acceptable.
Chairman, can I make one comment to that?
Hang on one. Okay, go ahead, Mr. Rich.
Thank you very much. While we normally wouldn't object to that, and it sounds reasonable, the next witness that we call is our construction expert, Mr. Gary Jones, and I think in most, if not all of these particular documents and many other Santee Cooper documents, Mr. Jones relies on those as part of his testimony, and more importantly provides what I mentioned earlier today, two additional bases for why they are they should be admitted. One is the whole notion of notice and what they knew at the time and the reason, and that's not for the truth of the matter asserted. And second is that these are the types of documents that are both reasonably relied upon and actually relied upon by the type of expert and in the type of testimony that you're about to hear. And it's why we made Ms. Warner our witness prior to Mr. Jones so that these issues could be dealt with right now. Thank you, Your Honor. Thank you, Mr. Chairman.
Mr. Chairman, I've read Mr. Jones's testimony. I am not aware of him, and I stand to be corrected if I'm wrong, relying specifically in his direct testimony on any of these particular documents. If that comes up, we can deal with it. If he has a basis to have them admitted based on his ability to do so, then we will deal with that when it happens. But I think as to the general blanket admissibility of these documents with no witness who can testify, if I'm hearing Ms. Warner correctly, even as to who wrote some of them, I think that needs to be dealt with through written briefing. There's hearsay in these documents. Business records cannot include opinions. There are opinions rife in these documents. Public records cannot include opinions. They cannot include hearsay. They can't include what someone else said who is not part of the organization typically. There are lots of detailed reasons why these documents have defects, and we think the way to deal with it at this stage is to brief that. And if Mr. Jones needs to rely on any of them, we can deal with that when that comes up.
Okay, what we'll do is you got something else?
May I mention one more thing? And I apologize for not mentioning it earlier, and I think I covered it this morning. But you know, when it is not hearsay because it's a public record, it's not subject to nitpicking within it. But more important than anything is that these are, in addition, admitted or should be admitted and are reliable because they are admissions of a party opponent. That rule encompasses agents, principals and agents in the course and scope of that. These are partners in this particular project. They were working and back and forth and contain both the public records, and it's that reason, those reasons of public records and admission against party opponents and those witnesses being just as much available to them as anyone else, that you can rely on these records and not be concerned about the reliability of it. And I think that, what we're looking for here in this a slightly more relaxed setting of evidentiary rules is what is reliable and the addition of reliability. And you've got it here. There's also a trade, the trademarks and exception that allows it when it has there's all kinds of arguments, and we can make an entire evidence class out of the arguments. But what it boils down to is that these are omissions of party opponent and public records, and once they're authenticated and actually are public records, that's the end of the inquiry. And I keep hearing a colleague talk about how it's got to have some sponsoring witness, and she's here, and she's available to cross-examination, but apparently they don't want to do that. But any context, any explanations, they've got 2 or 3 more weeks of testimony that they're welcome to provide. These records are clearly authentic, they're clearly reliable, and we believe strongly they should be admitted at this time. Thank you.
Okay, what?
I do not want to belabor this, but it is not our position that that Santee Cooper was SCE&G's agent in these matters. It is clearly a prejudice on our client to have documents come in where the author may, in some cases, is not known, where there's no one that you can cross-examine, no one you can just have a reasonable discussion with about what that document means, how it was used. The position ORS is taking is all you have to do to create a public record is to have a document show up in somebody's file at Santee Cooper. That's not the law. That's not the rule of evidence. And we would ask that the rule of evidence be applied, and we'll show where these documents fail under that rule, given the showing that has been made here today as to their admissibility under those rules.
Okay, we've got.
No more argument, but I'm told I did not actually ask that her testimony be read into the record, the pre-file testimony, and that's the proper protocol, and I apologize, Mr. Chairman.
We get to that. Okay, here's what we're going to do. We're gonna accept these subject to the exhibit, subject to the SC&G's objections. We're going to get the brief, let you brief the subject on all of those that you're opposed to. We're going to mark them as Exhibit 13 so that we can keep them in order and we'll know where they are. Okay, and Ms. Warner's testimony will be read into the record as if given orally from the stand.
Mr. Richardson, I understand there's direct, rebuttal, and amended. Do you want all 3 pieces of testimony into the record as if given orally?
Yes, we would, and I thought I had referred to those earlier, but maybe not by the right terms, but all of her testimony as if it was read into the record and adopted as she did in her testimody. We also would like to distinguish your ruling, if possible, that the 10 documents that have objections be handled the way you asked, but that all of the others that don't have objections go ahead and be admitted into evidence without objection.
Okay, as I understand the chairman's ruling, they're all admitted into the evidence subject to Mr. Ziegler's objections on the 10.
Thank you very much.
Correct, Mr. Chairman?
Correct.
All right.
Thank you very much. And last, if there's no cross, we would ask that Ms. Warner be excused.
Well, hang on one second. All right, got it. We're not going to call the roll here for cross, but we'll ask if anyone has cross that has you raise your hand, and we'll get to you. Come on up.
Your Honor, AARP just has 4 documents that we would like to see if the witness could identify for us. These are documents that have been attached to our expert witness's testimony, Mr. Scott Rubin. And I don't know if anyone else needs a copy of those. If I assume that counsel all has copies of Scott Rubin's direct testimony from September 18. If we do have, so we don't have, I don't have copies for everybody in the room, but we have about a dozen of them. If they would, if at least Santee Cooper or SC&G needs a copy of them, so that's just in a matter of explanation. Hi, I'm John Kaufman on behalf of AARP.
Mr. Kaufman.
Hi, Ms. Warner. Ms. Warner, have you had the opportunity to look at the direct testimony of Scott Rubin?
I have not.
This matter? Okay. Well, do you have permission to give the witness a copy? I should have flagged the particular pages for you, but
Yes, sir.
Chairman, I would object to this line of cross-examination as being far outside of the scope of the direct examination here. None of us, I believe, were prepared to make decisions about the attachments that were placed on the for the exhibits of another witness, and so we would ask that those issues be taken up when Mr. Rubin testifies.
Your Honor,
Are you sticking to her testimony in your cross? Because if they're attached to your witness, we need that to come up when your witness comes up.
my understanding is she's a witness here as someone who can identify business records, and I have 4 documents that are Santee Cooper documents. That's very similar to the ones that ORS went through, and given the way that the utility is raising some rather interesting arguments about business records, we thought that we ought to be careful and take this opportunity to verify the documents that we relied upon.
Okay, we'll let you verify those documents.
4 documents that I would like. Ms. Warner, could I direct you to this document, which is, I'm sorry, let me start with which is Exhibit SJR3, or SJR, actually 2. It's exhibits, the 4 documents are attached to Scott Rubin's September 18 testimony, SJR2, SJR3, SJR11, and SJR12. I'll put the first one up, which is, and let me say, first of all, these documents have confidential stamps that were put on them originally. It is our belief that these have all been made public documents through a Freedom of Information request, and that they were obtained as public documents by AARP. I don't know how easy it is to find. Have you been able to locate?
I have SJR2 in front of me.
Okay, and that's this document. It says internal memorandum from Howard Axelrod to Celeste Davis of Santee Cooper.
Yes.
And does that have a Bates number at the bottom?
Yes, it has a number DOJ 00176877.
Can you identify this document?
I can identify this document as a document drafted by Howard Axelrod of Energy Strategies, Inc., who was a consultant for Santee Cooper, to Celeste Davis, who was a Santee Cooper employee at the time. Document is a draft document dated March 11th, 2013, and is a summary report of Energy Strategies' VCS marketing activities. And I cannot tell you by simply looking at the document in which file it was kept at Santee Cooper, but I can tell you it was a document that was kept at Santee Cooper in our file.
Okay, thank you. I think that's all I need. And I'm going to move on to the next one, the next exhibit in that testimony, which is Exhibit SJR-3. It has an Energy Strategies, Inc. Title is the VC Summer Strategic Marketing Plan. And let me know, take a look at that, let me know if you can identify it.
Yes, I have this document, Bates stamp DOJ 00176901. It is a titled VC Summer Strategic Marketing Plan Summary Report prepared by Howard Axelrod, and it appears to be a document that was in the Santee Cooper files. Again, I would have to consult with our Bates numbering to determine exactly which file it came from.
And when the Bates number has a DOJ prefix, what does that mean?
That means the document was supplied to the Department of Justice in response to a subpoena.
Right. Thank you. And so is this, the second document that I've showed you, is that something that you believe would have been in the possession of Santee Cooper?
Yes.
And the third document I'm going to show you is, I guess, Exhibit SJR 11. It's 26 pages, entitled A Case Study of Economic Cost and Risks Associated with the Advanced Nuclear Generation and Combined Cycle Turbines. Take SJR 11.
Closer.
26 pages, and they consist of copies of some PowerPoints. They're kind of, and they're landscape sideways.
Yes, I have that document.
Can you identify that document?
It is DOJ number 000-83148. It is a case study of economic cost and risk associated with advanced nuclear generation and combined cycle gas turbines prepared by Howard Axelrod, our consultant for Santee Cooper, dated August 19th, 2013. And again, appears to be a Santee Cooper document, but I can't tell you the exact file it came from without further reference to the Bates numbering and production.
But it does it appear to you to be a document that was turned over in response to a Freedom of Information request?
It appears to be a document that was provided to the Department of Justice and likely also provided pursuant to other requests.
Okay. And then just to complete the loop, does this appear to be a document that would have been in the possession of Santee Cooper?
It does.
My last document is a 2-page document right after that. It is Exhibit SJR 12. It is a letter from Kevin J. Marsh. Whenever you get that and have a chance to look at it, and you can identify that, please.
This document has Bates stamp number DOJ 00202805. It is a letter on Santee Cooper letterhead from Lonnie Carter, our president and CEO, with what appears to be his signature, to Kevin Marsh, dated August 23rd, 2013, and it is a part of the DOJ production.
Is this a letter that would have been in the possession of Santee Cooper?
Yes, this appears to be a Santee Cooper business record.
Thank you very much for helping me out there. That's all the questions I have.
Thank you.
This witness.
Okay, Brother Cross. Microphone, please.
Would have a request. Mr. Richardson did a very nice job identifying these 10 disputed documents by Bates number, but would the chair consider taking these documents brought in by Ms. Warner and breaking them into 2 hearing exhibits, perhaps hearing exhibit 13 for the 10 disputed documents and hearing exhibit 14 for the rest?
Ms. Wheat says yes.
I should have asked Ms. Wheat first. Thank you, Mr. Chairman.
Disputed documents will be 13 and the rest will be 14. Okay. Mr. Ziegler.
Mr. Chairman, in the interest of clarity of the record, I think we ended up with 9 of the 10 being
You're right.
objections. So
Correct.
Sure, we're
Thank
clear
you.
about that.
Thank you for that correction.
Mr. Chairman. Mr.
I
Chairman.
just heard,
Yep.
heard a voice.
Yeah, may I ask the council a question, just briefly?
Go ahead.
All right. Mr. Ziegler, I'm going to ask you about your objection, just so that we're clear, because, as you know, hearsay evidence is admissible in an administrative proceeding, provided it's relevant and material. Now, are you objecting to the relevance or the materiality of these 9 documents?
Honor, my understanding is the commission operates under the rules of evidence, and that the Administrative Procedures Act very clearly states that that's the case when you're in a contested case situation.
Well,
There may be other rules, as I understand it, that apply. Excuse me.
now, I was just going to point out, South Carolina adopted the model APA as part of our code of laws. I believe it's 123-380G, something like that. And so the use of hearsay evidence does not violate due process principles as long as it's sufficiently reliable and trustworthy. And that's a minimal showing. It's not like a court of law where you've got to fit it into some exception to the hearsay rule. You agree?
I would say, Your Honor, that the SC&G is subject to substantial prejudice if any document that can be found in Santee Cooper's files can be admitted into evidence without the company having any ability to have a witness who can testify to its reliability to those indications.
Does that go to its weight and credibility as opposed to its admissibility?
I believe that it goes to its admissibility because it will be considered substantial evidence on any appeal. It's in the record, and that would be our concern, that if the company has to respond to every cold document, and here we just saw a number of documents related to a study done by an expert who's not here in the courtroom, is not available to be cross-examined, who I have no idea where that gentleman is. He's not been designated as a witness by any party, but the parties want to use his documents as if they had called him to the stand and put him up as an expert.
Well, if that's the case, a reasonable person wouldn't give that any weight, would they? And it goes back to the weight of the evidence.
I think it goes to the weight of the evidence, but by putting it in effect, you're saying it's valid evidence.
Not necessarily. No, we're the ultimate finders of fact.
Understood, Your Honor.
Yes, sir. And so the question becomes, should we have a chance to consider it all? And I think South Carolina case law says that we do. I'm going to ask you if you brief it. I'm going to ask both sides to look at South Carolina case law that's interpreted the Administrative Procedures Act as it relates to your objection. Because the only thing that the proponent has to show, and this would apply to you as well, is you offer evidence, hearsay evidence. All you have to show is it's reliable and trustworthy. And if we have a witness that's identified it for his business record, that's yet another reason why it would come in.
Your Honor, the fact that it was found in a particular set of files, to my mind, does not make it either reliable or trustworthy. It merely means that it was found.
You're making arguments now, but you've not even asked this witness a question. And I assume you don't intend to cross-examine her about that.
Your Honor, our position is that it is incumbent upon the party producing the record to make that showing. And when that showing was not made, no real effort was made to make it, it was our position, I think a logical one, that we could rely on the proffer that was being made and the authentication that was being made. We're not trying to show Ms. Warner has said anything wrong. We're not trying to impeach her statements that these were documents found in the files of the individuals concerned. We're saying that the showing is incomplete and insufficient, and that's the nature of our
Thank you, sir.
objection.
Thank you. Okay, we're still in cross, so Mr. Ziegler. Yes.
I'm just going to hold this here because I find these microphones work a lot better the closer you get them to your mouth. Mr. Warner, I'm Belton Ziegler. You and I have known each other for a number of years.
Yes, sir, Mr. Ziegler.
Couple of questions for you. You're familiar with the proposal that Santee Cooper made several days ago to set up a public interest fund. Is that correct? I don't want you to...
Warner, please get close to that mic when you answer, because nobody can hear you otherwise.
I don't want you to give me the substance of any communications that might have taken place with an attorney, but can you tell me when is the first time you heard about that?
Mr. Ziegler, I would have to tell you that would be attorney-client privileged information. From my perspective, I'm also counsel for Santee Cooper as well as a corporate secretary, and so I don't believe I could answer those questions without consulting with counsel about whether that would be attorney-client privilege.
I understand, Your Honor, Mr. Chairman, my understanding of attorney-client privilege is that the substance of a communication cannot be disclosed, but the fact that a communication occurred and the date and place of the communication is subject to disclosure. And so I'm only asking the date. And I don't care who it came from, but when did you first learn that that was something that Santee Cooper was considering putting before this commission?
I would say that the concept had been discussed, but the pleading was not formalized and the decision was not made until the last week. And in particular, as you know, there were negotiations going on between Dominion and SCANA and ORS early last week, leading up to a new filing by Dominion and SCANA last Thursday. And so the decision was made during the course of that week, and following that pleading, the final decision was made.
When was the first discussion?
The first discussion about exploring opportunities with Dominion and SCANA, as you know, took place when there was communication with Centerview a number of months ago, and over time, as the process went through with ORS and the PSC, we continued to consider our options.
All right.
And the decision was made last week.
Okay. And I'd just like the record to show that I've not been part of any of the discussions that you mentioned, and so that what you're saying is not something that I knew before you disclosed that to me. But those are the questions I have for Ms. Warner.
Thank you, Mr. Ziegler. Commissioners, any questions? Mr. Hamilton.
Ms. Warner?
Yes, sir.
Have you with us?
Thank you, sir.
Close to that mic,
Okay.
Commissioner.
We've discussed in the last few minutes communications that you've identified. Could I ask you what the basis was? Any of this in reference to the new nuclear development project?
The communications that I just discussed with Mr. Ziegler.
And with Mr. Richardson?
But I'm sorry, Commissioner Elam, I don't understand your question.
Okay. Tell me what is the subject of the communications that would be in reference to the nuclear project.
Yes, sir. In general, Santee Cooper has numerous files created and kept by numerous people who worked on the nuclear project over time. And so those documents were provided to numerous parties upon their request, including, as you've heard, the Department of Justice, ORS, the Governor's Office, responses to FOIAs. And so all of those, I think I'm answering your question, would be communications related to the nuclear project that were created by Santee Cooper or obtained by Santee Cooper or kept by Santee Cooper in its records.
Thank you, ma'am.
Commissioner Elam.
Prior to the abandonment, the nuclear abandonment, did Santee Cooper have any correspondence with ORS regarding the new nuclear development?
Commissioner Elam, I'm not familiar with every document that's in those files. I don't recall that there was any communication or any written communication with ORS. I think there may have been conversations on site, but I don't recall, and again, I would want to check our very voluminous files to confirm that, but I don't recall that there was any communication, any written communication with ORS on the subject, because as you know, we are not subject to PSC jurisdiction.
I've heard that somewhere. Santee Cooper had its own people on site,
Yes, sir.
and they would interact with ORS personnel.
I don't know that of my own knowledge, but I believe that there was some interaction.
Okay, thank you.
Commissioners, any other questions? Mr. Urban, you've... Oh,
No.
okay.
I do want to ask
Your
you
light was on.
one follow-up question. Back to the documents that you were identifying earlier. From your own personal knowledge, do you have the ability to tell us that those documents are reliable as part of your business records?
I can tell you that they are reliable in the sense that I've reviewed all of the documents and that they're all documents that were kept at Santee Cooper in the normal course of business. Many of them were created by Santee Cooper personnel associated with the nuclear project. Other documents were received by Santee Cooper personnel in the course of their duties in working on the nuclear project. Some were received from consultants for Santee Cooper during the course of the nuclear project. So in the sense that I believe that they are actual Santee Cooper documents and they are authentic and kept in the regular course of business, yes, sir, I do believe that.
Any doubt about that at all?
No, sir.
Are they material to the issues before the commission in this docket?
I would believe that they are, sir, as they are documents relating to the nuclear project.
Thank you.
Yes, sir.
Commissioner Whitfield.
Thank you, Mr. Chairman. Ms. Warner, this might be just a tad out of your purview, but I'm gonna take a stab at it. Mr. Hubbard mentioned the public interest fund, and then I'm not going to go down the path that Mr. Ziegler tried to go down with you about attorney-client privilege, but with Santee Cooper taking that policy, and as Commissioner Elam just said, we are all too familiar that we have no regulatory authority over Santee Cooper. What do you think, and I've certainly heard what Mr. Hubbard said for the benefit of the public, but this commission was not allowed to hear from any Santee Cooper witness from the inception of this case because we have no authority over Santee Cooper. Why now does the company think that however noble it might be, that it has a right, if you will, to suggest something like that, so to speak? Can you answer that, maybe?
I will do my best to answer that, sir, and I believe, Commissioner Whitfield, that it's not so much Santee Cooper's right as it is this commission's duty to consider the public interest, and the public interest is much broader than simply SCANA and its ratepayers in the context of this nuclear project, because Santee Cooper also had customers, wholesale and retail customers, who were the subject of the decisions that were made and the potential of this SCANA Dominion merger. So what we're simply asking the commission is that they consider all of the public interest as they go forward and make decisions about the SCANA Dominion merger, and that they consider conditions that take into account all of the public interest.
Okay, I guess what I'm trying to say is certainly we have influence over wholesale customers or jurisdiction that might impact a wholesale customer of SCE&G, an investor-owned utility. But so it's your opinion that this commission does have that jurisdiction, even though we don't regulate Santee Cooper or Santee Cooper's customers, the co-ops?
I would use the term authority rather than jurisdiction. I believe you do have the authority to create a public interest fund for the benefit of all customers, who were the subject of the nuclear project.
Well, thank you. That's all I have, Mr. Chairman.
Thank you. Commissioners, any other? Commissioner Elam.
And maybe you're not the witness to answer this, but the $1.1 billion from Toshiba that was the settlement in essence. Was Santee Cooper as a partner not entitled to part of that up front? I'm trying to understand that, whether it was just simply an agreement between SCANA and Toshiba, or...
I'm sorry, Commissioner Elam, I really don't have the information to adequately answer that question.
Okay, thank you.
Commissioners, any other questions? Any redirect? Okay, thank you. Okay, thank you, Ms. Warner. You may
Thank you,
step
sir.
down.
Mr. Chairman. Sorry, may Ms. Warner be excused as well?
Yeah.
Thank you, Mr. Chairman, Commissioners, Mr. Butler. Again, Jim Cox from the White firm in Greenville, appearing on behalf of the South Carolina ORS. The ORS would call as its next witness Mr. Gary C. Jones.
I do.
Mr. Jones, could you please state for the record your full name and city and state of record?
My full name is Gary Conrad Jones. I'm from Chicago, Illinois. My business address is 1555 North Astor Street, apartment 22W, in Chicago, 60610.
Mr. Jones, what is your occupation?
I'm a consulting engineer, president of my own firm, Jones Partners Limited.
And what does your firm do, Mr. Jones?
We provide, I provide consulting services to the power industry.
Mr. Jones, did you prepare 33 pages of direct testimony that was pre-filed in these proceedings on September 24th, 2018?
Yes.
Mr. Jones, do you have any changes, updates, or corrections to that pre-filed direct testimony?
Not at this time.
Mr. Jones, if I asked you the questions in your pre-filed direct testimony during this hearing, would your answer to those questions be the same as in your pre-filed testimony?
Yes.
Mr. Chairman, at this time, the ORS would move into the record the pre-filed direct hearing testimony of Mr. Gary Jones, as if given orally from the stand.
Pre-filed direct testimony of Mr. Gary Jones will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. Mr. Jones, did you also compile 12 exhibits with a number of sub-exhibits labeled GCJ1 through GCJ12 that were pre-filed with your direct testimony in this manner?
Yes.
And Mr. Jones, are these exhibits documents that an expert in your field would reasonably rely on to form expert opinions?
Yes.
And Mr. Jones, did you rely on these documents to form opinions in this matter?
Yes.
And I know there's a number of documents there, Mr. Jones, but can you tell generally, is there a general statement you would make as to how these documents were used in your opinions?
Well, these documents were reviewed. In one case, we prepared a timeline, which is represented by the big chart that's been in the room all this time. That was my Exhibit 2. In that timeline, then, we identified various key milestones of the project and also key documents that supported both those milestones and the status of the project and what was going on the project at that time. And they reflected documents, many of which were found during discovery, that provided relevant information for my testimony.
And Mr. Jones, do you have any changes to the content of the exhibits that you included with your direct testimony in this matter?
No, not at this time.
Mr. Chairman, at this time, I would ask that the confidential version of Mr. Jones's exhibits GCJ 1 through GCJ 12 be entered into the record as the next composite hearing exhibit. At the time that Mr. Jones filed these exhibits, some of these documents had been labeled confidential by SCENG, and my understanding now is that those designations have been removed, so the confidential version of those 12 exhibits can now be entered publicly as the next hearing exhibit in this matter.
Okay, the Mr. Jones exhibits GCJ 1 through 12 will be entered into the record as exhibit number 15.
Chair, may I make an inquiry?
Yes, sir.
As a non-party to the confidentiality agreement on matter of principle, I would now just wonder whether these now non-confidential documents are now available to all parties, including my clients. Is there an unexpurgated or unredacted version of these exhibits? I've not had an opportunity to see any of the so-called secret documents that have been withheld by the company.
If they're no longer confidential, they're available to everyone, according to Mr. Butler.
And Mr.
Wait, Mr.
Two things. Mr. Chairman, there is no confidentiality agreement. There's actually a protective order that David Butler put in place at the outset of this hearing. So
that's what I mean to refer to. Excuse me. Yes.
And then number two, I believe ORS has filed these with the commission in their unredacted form, if I'm not mistaken. So Mr. Gall should have access to those by way of being a party in this case.
Thank you.
Well, that's my inquiry, I guess. If they were filed in a redacted or a confidential form and now they're no longer confidential, have they since been refiled in a public form that would be accessible to the public and all other parties? That's my query.
Mr. Gall, my information is that the ones that became public from the non-public were filed as public. Now, in other words, they're available on a document.
All available. Thank you.
That's my understanding now.
The only ones served on us have been heavily redacted, and so I'm sort of flying a bit blind, as maybe some others are. But if they're all now publicly filed with the commission, that answers my question.
That's my understanding, sir.
Mr. Chairman and Mr. Butler, that's my understanding as well. Mr. Jones, did you also prepare 4 pages of rebuttal testimony that was pre-filed in these proceedings on October 24th, 2018?
Yes.
Do you have any changes, edits, or corrections to that pre-filed rebuttal testimony?
Not at this time, no.
Mr. Jones, if I asked you the questions in that rebuttal testimony during this hearing, would your answers to those questions be the same as in your pre-filed testimony?
Yes.
Mr. Chairman, at this time, ORS would move for admission into the record the pre-filed rebuttal testimony of Mr. Gary Jones as if given orally from the stand.
Mr. Jones' pre-filed rebuttal testimony will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. Mr. Jones, did you also prepare 18 pages of rebuttal pre-hearing testimony that was pre-filed in these proceedings on October 29th, 2018?
Yes.
Do you have any changes, edits, or corrections to that pre-filed rebuttal testimony?
Not at this time.
And Mr. Jones, if I asked you the questions in that surrebuttal testimony during this hearing, would your answer to those questions be the same as in your pre-filed testimony?
Yes.
Mr. Chairman, at this time, the ORS would also move for admission into the record the pre-filed surrebuttal testimony of Mr. Gary Jones as if given orally from the stand.
Okay, the pre-filed surrebuttal testimony of Mr. Gary Jones will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. And lastly, Mr. Jones, did you also, contemporaneously with your surrebuttal testimony, compile 12 exhibits labeled as Exhibits GCJ1 through GCJ12 that were also pre-filed with your surrebuttal testimony?
Yes.
And Mr. Jones, are those exhibits attached to your surrebuttal testimony documents that an expert in your field would reasonably rely on to form expert opinions?
Yes.
And Mr. Jones, did you in fact rely on those documents in forming your opinions?
I did.
Mr. Chairman, at this time, the ORS would move for admission into the record the exhibits GCJ1 through GCJ12 to be entered into the record as a hearing exhibit. I note that some of those exhibits are still considered labeled confidential, I believe, by SCE&G. So I would ask that two hearing exhibits be created. The first for the non-confidential exhibits attached to his testimony, consisting of GCJ 1, 2, 4, 5, 6, 7, 8, 10, and 11.
Sir, as I understand it, it won't be necessary to do that. Our court reporters can separate out the confidential from the non-confidential with just one hearing exhibit number. So,
thank you, Mr. Butler.
That'll be fine.
We'll do the surrebuttal as exhibit number, surrebuttal exhibits 1 through 12. GCJ 1 through 12 is exhibit 16.
Thank you, Mr. Chairman. Mr. Jones, have you prepared a summary of your...
Mr. Chairman.
Mr. Gile.
Pardon me for interrupting, counsel. I would move that the confidentiality be removed from any documents that are filed in support of, in the record as evidence in this case. We certainly have not consented to any confidentiality treatment. As stated, have resisted participating in any confidentiality protections or order, have not had access to any confidential evidence in this case, believe it all should be made public, and believe the burden should be on SCE&G or any other party to support any claim of confidentiality. So if there are any remaining confidential documents as part of the offered exhibit, we object to their being treated as confidential non-public material and ask the Commission to order that they be made public at this time.
I'm looking at a copy of a summary that was provided to us that contains some highlighting, noting confidential material in the summary. And I don't know if that's what you've given everyone else or whether that the reference in the summary is no longer confidential or still is, or what?
Thank you, Mr. Commissioner. I failed to mention this earlier and should have. A surrebuttal testimony of Mr. Jones that was pre-filed did include citations to material that had been designated confidential by SCE&G. However, we've reviewed that testimony that was previously designated as confidential, and the testimony quoted there is no longer designated as confidential by SCE&G. Those quotations, I believe, solely came from Ms. Walker's deposition transcript, which has no longer been designated confidential. So I believe that the surrebuttal testimony of Mr. Jones that was pre-filed, the confidential version can be entered into the record in whole.
Mr. Burgess.
I would agree with everything Mr. Cox has said, with the exception of one thing. There is one reference in Mr. Jones's sir rebuttal testimony to Mr. Brown's deposition testimony. And I believe, and if you'll give me 1 second to confer with my co-counsel, I believe that that particular piece that's being redacted was the substance of an objection that was laid down at the deposition because it sought to elicit attorney-client privilege information. So just give me 1 second, if you may, Mr. Chairman. I'm correct on that point, Mr. Chairman. So we would ask that that one particular designation in Mr. Jones's testimony remain redacted because it is subject to a conversation that was had between counsel and the deponent at the time.
Mr. Chairman, may I respond?
Sure.
Thank you, Mr. Chairman. We reviewed this testimony, and we disagree with SC&G's basis for their objection, their confidentiality designation on this document. But even given what I understand to be the nature of their designation, we don't believe that this quotation encompasses that material.
Mr. Chairman, my name is John Challey. I represent SCE&G in this matter. To respond to Mr. Cox's statement just now, the portion of Mr. Brown's deposition that is still subject to a claim of confidentiality is the portion that relates to a discussion that we believe to be privileged. There may be portions of that that we can revisit that confidentiality designation on, and we've discussed with Mr. Cox and the ORS today our intent to do just that. We're happy to do that, but as far as where we are today, the portion of Mr. Brown's deposition transcript that is referred to in Mr. Jones's testimony is still subject to a claim of confidentiality because we believe it relates to privileged advice provided during that discussion with Mr. Brown.
Where is that? I know Commissioner Elam has had that question.
They did.
And I'm also not sure whether that affects this written summary.
I would add, that's exactly right. The written summary also reveals or references the very same exchange as to which we are still we have maintained and are evaluating now our claim of confidentiality as to that issue. And the summary repeats in substance what the sir rebuttal provides. The sir rebuttal site is on page 5 of Mr. Jones' sir rebuttal, where he is reporting on what he purports to have learned from Mr. Brown's deposition testimony, and that is in sum and substance the same that Mr. Jones is providing in the summary that he handed to us today on page 6.
Okay, is that everything on page 6 of the summary, or is it what starts at line 7?
It's only what starts on line 7, Mr. Commissioner.
I think I may be able to help. Do you recall me asking you all to set out a line-by-line summary of anything that you thought was still confidential in Mr. Brown and Ms. Walker's testimony by today at noon?
We certainly recall that direction as it relates to Ms. Walker's testimony, and we have concluded that no aspect of Ms. Walker's testimony needs to remain confidential. We have, as I alluded to earlier, have had discussions with the ORS about attempting to reach a similar accommodation with respect to Mr. Brown's testimony, and we intend to do so as promptly as possible. We have not reached that conclusion just yet.
Okay. All right. You do not recall me asking for Mr. Brown's information on Mr. Brown's by noon today?
Mr. Chairman, I do recall you issuing a hearing officer directive, and I, subject to rereading it, I don't doubt you in saying that, or you're questioning us in the fact that Mr. Brown was subject to that 12 noon requirement as well. There has been a lot of flurry of activity going on here with council today. So to the extent that we have missed your deadline, the only thing I can say is we apologize for missing that deadline. We would like the opportunity, and we can consult with ORS's counsel very quickly and see if we can't resolve this issue before the commission.
Okay, Mr. Guile, we haven't forgotten you. Just wondering, we've sort of gone down a couple of streets there. Okay, Mr. Guile, we're going to hold your objection or motion in abeyance right now and rule on that. We're going to give you the chance to all of you a chance to talk this over since we've had a flurry of activity. And it's 4:30, and we're adjourned till tomorrow morning at 9 o'clock.
Thank you, Mr. Chairman.